Greetings, Twitter X. I wanted to go live tonight, although my original plan was to talk about the abortion hearings, Zorowski versus Texas, that occurred in the Texas Supreme Court on Tuesday. But given that there were unforeseen events that occurred both yesterday and today, I decided to change my topic just a little bit because something else came up that I think is more interesting, and I wanted to try to talk a little bit about that. Three major things have occurred this week here in Texas. One was the abortion hearing. The second was that in the city of Amarillo, in the federal court, Amarillo, Texas, had originally sued the U.S., requesting a preliminary or permanent injunction so that the U.S. would stop destroying or cutting or removing segments of the Concertina wire on the Texas-Mexico border. The judge in that case decided that Texas would not be awarded the preliminary injunction at all. I believe in that case it was because it basically boiled down to that the argument that Texas was proposing was that the sovereign immunity, which means that the U.S. would be immune from these type of lawsuits. Basically, what they're saying is that the U.S., the sovereign immunity would have been waived because the state of Texas sustained damages, whether monetary or non-monetary. I'm not exactly what the terminology is there. But basically, what the judge said is because that particular statute applies to an individual person, that it doesn't necessarily apply to states' claims. So he said, not so much, you're not getting the injunction. That was yesterday. Now, I had saw that, and I was reading it throughout the course of the morning today, and I was thinking of talking about this after I did the abortion hearing. Now, as I was getting my things together and getting ready to go live earlier, the U.S. Court of Appeals, Circuit Court of Appeals, for the Fifth Circuit, issued a ruling and opinion on the other lawsuit that was the U.S. suing Texas to remove the border buoys and the Concertina wire. Now, that case, what had happened was that the U.S. went seeking the preliminary injunction. The district court, they got it. However, that the state of Texas appealed it to the Fifth Circuit Court of Appeals, and they issued a stay while they were hearing the arguments on the preliminary injunction. And basically, the three-panel Circuit Court of Appeal judges stated and said that, unfortunately, Texas. Basically, they said, okay, we're going to dissolve the stay because, unfortunately, Texas does not have. They're not going to be able to win on the merits of the case, and they went into the details in the ruling where they stated certain factors. I'm going to try to cover those factors here in just a minute. Basically, they said, okay, Texas, not so fast. You're going to have to move the border buoys and the Concertina wire. So we have two rulings against Texas. One, a lawsuit that they instigated, and the other one where the U.S. filed a lawsuit against Texas. And for the same purpose, same theme, and they're both, the rulings favored the U.S. So yeah, it's interesting. So, but I want to talk about the ruling from the Circuit Court of Appeals because that's the higher court right now. And I believe that when it boils down to it, these two lawsuits, it's going to be about precedents, and basically one court's ruling is going to be a precedent for the other. And so it's going to be very interesting to see how it plays out. Now, I have the printed copy, and I'm showing it to you here on my screen, of the Fifth Circuit Court of Appeals ruling. the opinion. I read it, and I want to talk about 3 central points that I believe are going to complicate the issue, and it's going to make it extremely difficult, if not impossible, for the state of Texas to prevail in this lawsuit. Okay. In the beginning of this ruling, in the first paragraph, it mentions that the U.S. is alleging that Texas is violating the Rivers and Harbors Appropriation Act, and I've got it highlighted, which is the RHA, Section 10, it says. Now, let's look at Section 10, and I want to read it and go over it because there's something in it that I want to touch base on, and I think it is part of misunderstanding between the parties, and I want to read it and point out what's going on. This is if you look on the screen here, this is the actual paragraph of that section. It's in the appeals Court of Appeals ruling, and I'm gonna basically go to main screen here, make it full screen so you can see it better. And it reads this way. It says, the creation of any obstruction not affirmatively authorized by Congress to the navigable capacity of any of the waters of the United States is prohibited, and it shall not be lawful to build or commence the building of any wharf, pier, dolphin, boom, weir, breakwater, bulkhead, jerry, or other structures in any navigable river of the United States, except on plans recommended by the Chief of Engineers and authorized by the Secretary of the Army. There's 2 main points in this section where I believe that Texas is going to have a very difficult, if not impossible, time in defending their appeal against this ruling. And that is, the first one is where at the beginning, where it says the creation of any obstruction not affirmatively authorized by Congress to the navigable capacity of any of the waters of the United States. The argument that Texas is proposing here in this lawsuit is that they talk about whether or not the Rio Grande is navigable waters. Now, I believe the determination on that is made by the Army Corps of Engineers, the Secretary of the Army, they are the ones that determine whether a river is or is not navigable. And I believe the Rio Grande has been declared by them as navigable. Now, the issue here is not what I think here in this paragraph is not whether the Rio Grande is navigable or not. It's the fact that it says, okay, the creation of any obstruction not authorized by Congress of any of the waters of the United States. And basically, that it affects the navigable capacity of any of the waters. It's not necessarily saying whether or not the waters are navigable. I mean, it does specify it in any navigable river of the United States, but it's more clear at the beginning where it says in any of the waters of the United States is prohibited. So you got a RHA violation, direct violation there that Texas is guilty of. The second part is the permission at the end of the second clause, the permission, that Texas was supposed to request permission before they did what they did. They never did at all. And it's that lack of permission that is going to be, in part, is going to be one of the underlying factors that is going to cause them to really have difficulty in winning their case. If we look at that bottom sentence in that paragraph, it says, the second clause prohibits the construction of specified and other structures, which the judges are referring to the Concertina wire and the Buoys as other structures. And it says, the second clause prohibits the construction of specified and other structures in those navigable waters absent permission from the Corps. So basically, Texas, you didn't have permission, and because you didn't have permission, what you did was unauthorized, and it has to be moved. That's what that's basically what they're saying in a sense. So, second here. And we're going to go back to my screen here. Sorry about that. So that's basically, those are the first two focal arguments that I see with difficulty for Texas in trying to prevail in an appeal against this ruling. The second one is something that I mentioned, and I'm going to pull it up here in a minute. Something that I mentioned before when I initially talked about these lawsuits when they first were filed, and that is I said that Texas is going to have a difficult time prevailing because of precedent. And I specifically mentioned a Supreme Court precedent, which was Arizona versus the United States. Okay? And that was in 2011, 2012. Arizona, the background here is that Arizona passed a law called SB 1070 that allowed Arizona to enforce immigration law. It was the U.S. sued at the federal level. The case went up all the way to the Supreme Court, and the Supreme Court ruled that Arizona could not enforce the law because they're not allowed to enforce federal law. Now let's look at what the appeals circuit judges mentioned in their ruling, and this is on page 26, I believe, of the ruling. Let me pull it up and you can see it, and then I'm going to go to full screen and let you see it. It says the district court, in finding that the public interest favored the United States, it says, emphasized Supreme Court decisions. Interesting, huh? It says, and it talks about the Sanitary District of Chicago versus U.S. Supreme Court stated there's no question that its power to remove obstructions to interstate and foreign commerce is superior to that of the states to provide for the welfare and necessities of their inhabitants. More pointedly, let's look at that bottom paragraph sentence. It says, in Arizona versus the United States, 567 U.S. 387, 2012, it says, the Supreme Court noted that while Arizona may have understandable frustrations with problems caused by illegal immigration, which Texas has alleged, basically the same issue that Texas is proposing right now, it says the state may not pursue policies that undermine federal law. Basically, what Texas is, what the appeals court justices are saying is that Texas, mind you, cannot enforce federal law. Basically, he's saying, okay, because of a supremacy clause in the Constitution, Texas cannot prevail in this specific type of a lawsuit because, unfortunately, the federal government's interests outweigh the state's claims. And if we look at, and if you were to go to the next page on that same ruling on 27, the first sentence says further, and I don't have it on a digital image because I didn't have time to get it up there, but it says further, the district court emphasized that the balance of priorities Congress struck in the RHA outweighed Texas's asserted interest. Wow. It said the district court relied on all the evidence discussed here to find that the balance of hardships tips in favor of the United States. Okay, it considered the threat to navigation and federal government operations on the Rio Grande, as well as the potential threat to human life and the floating barrier, yada yada. Basically saying, okay, the U.S. interests outweigh the states. So it's basically supremacy clause argument there. And in a supremacy clause argument, everybody knows that the U.S. will always prevail. So that's the third focal point that I believe that will complicate matters for the U.S. For Texas, in these lawsuits. So, and it makes it interesting because, as I said with these lawsuits, it's all going to be precedents. I mean, you've got the overlying precedent from the Supreme Court in Arizona versus the United States. And now you're going to have precedents. Basically, the appeals court ruling is going to be another precedent against the lawsuit in Amarillo that Texas has against the U.S. And in the lawsuit, in this appeals court lawsuit, you've got the Supreme Court precedent mentioned in the ruling, mind you, and then they can easily flip it and refer, or not flip it, they can easily refer to, okay, you have a court case in Amarillo where they ruled against you, where they ruled against you because you have no claims. So the fact of the matter that both cases ended up with the same basic result is basically a two-edged sword, a double-edged sword against Texas. I mean, I don't see them in any way, shape, or form really being successful at this point. But it will be interesting to see what the state writes in its appeal. And I'm waiting for them. I'm going to wait for them to publish the appeal that I can see it and see basically what the arguments are that Texas is going to propose trying to fight this, because it's going to be interesting to see that. In all honesty. Because, I mean, if one lawsuit would have worked in their favor, then I would say, okay, we have split decision. And with split decision, that would, I guarantee you, would probably go all the way to the U.S. Supreme Court. One moment. Sorry about that, my throat. But in this case, we have two correlated rulings. One on the appeals level and one on the district court level. Although the district court level is now in favor of the U.S. So, I mean, everything is favoring the U.S. in that sense. It's going to be interesting to see how this all plays out in the end. But I'm going to wait and see what the appeals, the appeals come out and see what they say, because it's going to be interesting. I will try to come out tomorrow live again, because I do want to talk about the abortion hearing in the Texas State Supreme Court. I actually got to watch that twice. Interesting little story about that. I mean, I watched it one time, and for some reason earlier I was doing something, and I went to click on it, and to watch something on my phone, and it came up again, so I decided to watch it again. So, but it's interesting how it played out. I will talk about that. Hopefully, I'm going to try and make time to come live again tomorrow to talk about it, and we'll go from there. Side note, I mentioned not too long ago that I was inadvertently, I won't say inadvertently, but I don't know if that's the case, but I was blocked by the State Attorney General of Texas on his personal Twitter feed. I didn't think much of it, because I was like, okay, well, maybe, I thought maybe I had said something to offend, but I was like, okay, if it happened, it happened. I'm not gonna deal with it. I'm not gonna argue with it. I felt that, okay, well, a lot of the stuff that I post is objective, and so the fact that he blocked me, I figured he had a reason for doing it. There was a tweet that I put where I mentioned 3 little words that are legal terminology that kind of insinuated that maybe there was something more to the story in one of the articles, and I thought that maybe that was the reason why he blocked. But suffice it to say, I got on yesterday on my Twitter feed, and the first thing I saw was a tweet from Ken Paxton, Texas, and I was like, okay, wait a minute, how can I see this if I'm blocked? So I had to say, I delved a little bit deeper, and I found out that I'm unblocked. So I'm kind of happy about it in a way. But, I mean, either way going forward, I am going to try to be as objective as I can with all my comments. I mean, that's what I've always tried to do for, most everything that I've discussed on this Twitter feed has been with respect to lawsuits and my objective viewpoint or perspective on them. I try not to get too politically involved in anything, because our political environment today is so charged up, that it's very easy to get poisoned by either the conservative party or the conservative side or the liberal side. And I'd rather not be involved in that poisoning myself. So I try to be as impartial and as objective in all my comments as I can. That's why a lot of times when I have commented, like example, when I've commented about his impeachment, I didn't focus on the fact, okay, you're guilty, or you're not guilty. My main focus was in observations that I've made while watching the impeachment footage myself, the impeachment trial. I pointed out that there was a lot of inconsistencies, and I pointed them out. And the one thing that I did make clear, and I don't know if it may have been taken into offense, was I said when he was acquitted, I said, okay, you were acquitted, but you may have won the battle, but you have yet to win the war, because you still have the securities fraud investigation, you still have the actual lawsuit, but whistleblower lawsuit to deal with, and you have these things going on. So to count yourself victorious right now, you don't want to count your chickens before they've hatched. It's what I said in a nutshell, and I kept pressing that because I kept pressing that because I wanted to make sure that not only was the Attorney General aware, but because he'll post something and say, okay, I was acquitted, yada yada, and people are going to be applauding him and say, yeah, go for it, congratulations, you were victorious. But a lot of people might think and say, okay, well, that's the end of it, and he's good to go. But I wanted to press it. I pressed it because I wanted to make sure people were aware that was not the end of the story, basically. So, but going forward, I'm gonna be as objective as I can in commenting. I try to be as impartial as I can because I do not want to be poisoned by either side of the political spectrum. I want to give my objective opinion because I think that there's a lot of people that are so wrapped up politically on either side of the spectrum that they fail to see and observe the logical aspects of what's going on. And I think as Americans, we need to take the time to do that. To look at things from. I've always said from the very beginning. I've said we need to look at this from outside the box. When I mean up outside the box, I'm saying outside of the political spectrum. We need to look and see if everything is morally right, ethically right, spiritually right. Because a lot of the times, even though we think it's right politically, it's not necessarily ethically, morally, socially, spiritually right. And I think we need to be aware of that. And so that's the reason why I try to be as objective as I can. That's why if you see on the logo on the screen here, you'll see a logo that says "Open Point of View." I'm trying to give an open point of view, being an objective as I can because of that. But now that he's unblocked me, I'm happy. I'm not going to try to abuse that privilege. I'm going to try to be as objective as I can going forward. I may not post as much as I used to on his Twitter. I'm going to try to respect him in that respect a little because I don't want to also seem like I'm trolling. But I do want to be as objective in my comments so that people are aware. Look at this from an outside point of view. Look at what's logical in this. What's right, what's wrong, before you make a decision. I do the same thing on the governor's Twitter. I do the same thing I go on a lot of the House representatives and senators' Twitters, and I do the same thing. I try to point out, my comments as objectively as I can for that reason. Because what is politically right is not necessarily ethically or morally right or spiritually right. And I think, as I said before, I think that's something that we all as Americans need to really think about going forward. But that was just a side note, so I'm going to go ahead and bid y'all a fond adieu. And we'll, as I said, when I go live again, we'll talk about the Texas Supreme Court hearing. That'll be my next topic, and on the next live stream, which hopefully will be, I believe, tomorrow. And I'll see you then on the next.